Welcome, everyone. Thank you for joining the San Francisco Superior Court Elimination of Bias Committee today as we celebrate the conclusion of Hispanic Heritage Month. My name is Judge Suzanne Bolanos. I'm the chair of the committee, and also with me is Mr. Terrence Evans, president, chair of CLA, and a partner at Duane Morris, also on the committee. Today, as we conclude Hispanic Heritage Month, we want to reaffirm our commitment to justice, equity, and inclusion at all levels of the legal profession. And to that end, we're going to focus today on attracting new members and future leaders of the profession. I am delighted to introduce as our distinguished speaker on the topic of defending diversity in education, Professor Rachel Moran. Rachel Moran is a professor of law at Texas A&M University School of Law. Before that, she served on the faculty of UC Irvine School of Law, which she helped to found, UC Berkeley School of Law, and UCLA School of Law, where she also served as dean. Professor Moran has written over 100 articles, book chapters, and short commentaries exploring such topics as bilingual education, desegregation, and affirmative action. In addition, she's co-author of one of the most widely adopted case books in the field, Educational Policy and the Law. Professor Moran also has published widely on questions of race and the law. Her work includes two highly regarded books on the subject, Interracial Intimacy, The Regulation of Race and Romance, and Race Law Stories. Professor Moran is highly active and always has been for many years in the legal and educational community. She joins us today to talk to us about defending diversity in education. So, Professor Moran.
Well, thank you, Judge, for that kind introduction, as well as for the invitation to be here today. It really is a pleasure to join you. I look forward to our conversation. I also want to thank everyone in the audience who's taken time from busy schedules to join us in this important discussion of some of the challenges that we'll be facing in legal education and the legal profession as a result of some developments in the field of diversity. So I'm just going to take a moment to share my screen. And I wanted to just begin here by taking a look at the overview of what we're going to be discussing. We're going to start with a 2023 United States Supreme Court decision in Students for Fair Admissions versus President and Fellows of Harvard University. As I'm sure all of you are aware, that case rejected the use of race in higher education admissions at both a premier private and an elite public flagship university. Next, we're going to turn to some of the developments after the case, starting with the most obvious area, admissions. And then what I want to do is take a look at how this case has shaped discourse well beyond admissions with respect to hiring, with respect to curriculum and even law reviews, as well as diversity, equity, and inclusion initiatives. So let's just start with the case itself. In the summer of 2023, the United States Supreme Court handed down a decision that struck down race-conscious admissions, as I mentioned, at Harvard and the University of North Carolina. I don't think the case came as a tremendous surprise to court watchers. I think it was widely anticipated that the court would likely reach this conclusion. But it still did overturn decades of precedent, beginning with the Bakke case, which came out of California, right here at the University of California at Davis, where the court had said that in higher education, diversity is a compelling interest. And so colleges and universities could consider race in admissions because race was a way to achieve diversity and thus a robust exchange of ideas and perspectives. Now, what happened in the Students for Fair Admissions case is that the court did not actually say that diversity is bad. It didn't reject diversity. What it said is that racial categories are so internally varied, they're so heterogeneous that they are not a good predictor of ideology or perspective. And so when Harvard and the University of North Carolina relied on these classifications as proxies for people's ideas, they engaged in illicit stereotyping and also didn't have a good way to achieve the ultimate goal, which was the diverse exchange of ideas. So after this decision, which relied on equal protection for the University of North Carolina and Title VI for Harvard, basically all public and private universities were faced with the task of revamping their race-conscious admissions programs and figuring out how to make them race neutral facially, and in some cases, operationally race blind. For example, if you don't ask about race in any way, or you don't ask, have a prompt for the essays, which the court said could consider race. So after the Harvard and University of North Carolina decisions, there's been kind of a mixed bag with respect to the racial and ethnic composition of the entering college classes. We don't have complete data yet. The results are still trickling in. But what you see is that there are universities like MIT that saw dramatic drops in Black and Latinx enrollment. Others, like Harvard, saw a more modest decline in Black enrollments and actually saw an increase in Latinx enrollments. Princeton and Yale actually didn't experience any change in their Black and Latinx enrollments, and they had a slight decline in Asian American enrollments. Now, after the Students for Fair Admission decision, Edward Bloom, who is the organization's founder, warned that they would be watching. They would be looking at the outcomes. And if they suspected that race continued to play a role in the process, there would be consequences. And so what has happened is that Bloom has sent warning letters to Princeton and Yale because they didn't see any change in their racial profile, their demographics of the student body, and also to Duke, which similarly didn't experience any major changes. And so if you see here in the upper right-hand corner, it was basically kind of a warning letter. You are now on notice. And the letter asks these universities to explain how they got these results without considering race. So there hasn't yet been a lawsuit filed, but the assumption is that that very well may happen after these warning letters went out. Now, we're probably more interested in what's happening in law school admissions. And the truth is, it's just too early to tell. We haven't yet gotten the release of information about the racial and ethnic makeup of the entering law school classes. We do know that the pool of applicants remained diverse, but we don't know what the actual enrollments are. Now, one reason that we can't be sure is because when you look, the pool is diverse. It still has robust numbers of Black and Latinx applicants, but many people do not apply randomly to law school. So most of the applications are concentrated on a subset of competitive law schools. And so we really don't know how the enrollments will sort out. We also don't know if after the data are released, SFFA will announce any intent to sue law schools over their admissions results. Now, even before we knew the effect on the numbers, the American Bar Association Council on Legal Education, which oversees, along with its section on legal education, the accrediting process, recently proposed changes to the standard on diversity and inclusion. And you'll see that those changes really do two key things. One is that they argue that you need more categories. We can't just focus on race and gender. We need to look at other things like disability, veteran status, being a first-generation student, all kinds of other traits that they believe bear on these issues of having a kind of diverse student body. But the other thing that has become problematic is that they've tended to wipe out the references to diversity and substitute access for that term. And so some people feel that they are essentially preemptively conceding that diversity is no longer the objective. And instead, they're trying to find some other language like access that will be more palatable. And in fact, two law professors at the University of California, Berkeley School of Law, Jonathan Glader and Russell Robinson, issued a letter that they asked faculty to sign on to, criticizing the ABA for what they saw as a kind of preemptive surrender on issues of diversity. And if you look at the letter, one of the things that they say here is that opponents of racial equality are using the SFFA decision to attack the mere presence of people of color in college classes, on law faculties, and in the legal profession. They seek to goad the conservative justices to issue a broad, absolutist opinion that would bar even race-neutral efforts to promote diversity. The ABA ought not to acquiesce to this project. Now, that's important because it highlights another development that has been going on simultaneously with the court's consideration of race-based affirmative action in admissions in higher education. And that is a series of cases challenging race-neutral admissions in magnet schools. So these cases typically involve high schools that have competitive admissions. You are undoubtedly familiar with the Lowell High School, which had competitive admissions, and we see similar kinds of admissions in Boston, in Fairfax County, Virginia, New York City. And so these schools, particularly in the wake of the George Floyd death and the rise of the Black Lives Matters movement, actually wanted to think about changing their admissions policies in order to promote diversity. Now, those admissions policies were not necessarily race-based, and the revised admissions policies were not race-based either. Nonetheless, the Pacific Legal Foundation, which brought most of these cases, though not all of them, argued that these policies have a disparate impact on some students, and it's typically Asian American students and in some instances white students. But the argument is that even though these policies are facially race neutral, so they don't use race as an explicit consideration in allocating seats in these competitive schools, they are nonetheless motivated by discriminatory intent. Now, what's interesting here is that the Pacific Legal Foundation and the plaintiffs are arguing that even though this is facially race neutral, there is covert racial balancing going on. And so this is an interesting set of cases. So far, the lower courts have rejected the claims, and the US Supreme Court has declined to intervene. In particular, in a case called Coalition for TJ, the court rejected the effort to grant certiorari over a vigorous dissent by Justices Alito and Thomas. And Alito and Thomas said that the court should take the case because these decisions were going to have a significant role to play in defining disparate impact. And they thought that the lower courts, by rejecting the plaintiff's claims, really got it wrong. Now, although the court declined to grant certiorari in this Virginia case, it's actually currently contemplating a petition for certiorari in another case out of Boston that raises similar issues. So far, they haven't yet decided whether to hear the case. They said it was going to go to conference last month and twice this month. So we're going to see if it goes to conference on October 18, and if so, what the court decides. So we're just waiting to hear from the court as to whether they'll hear this lawsuit. Now, I wanted to just give you a sense of what the issues in the lawsuits are. The main focus has been disparate impact. What does it mean? And discriminatory intent. Again, what does it mean? Now, when we had race-conscious classifications, they did a lot of work because a victim didn't have to show that they would have been admitted in the absence of those classifications, and they were presumed to inflict harm simply because they made race an explicit consideration in the decision-making process. But now these are facially race neutral. And so one question is, how do we decide whether these policies even disparately impact a racial or ethnic group? So one school of thought is all you need to do is take the old results under the old admissions policy and compare them to the new results under the new admissions policy. And if there are disparities in those results, there's a disparate impact. And in most of the cases, it's a disparate impact on Asian American applicants. Now, what's so interesting to me is the Pacific Legal Foundation has just used the raw numbers. It hasn't really tried to do any sophisticated statistical analysis. And so it really hasn't allowed us to figure out whether even the changes are statistically significant, whether if a multiple regression analysis were used, some other factors explain those differences. It's a very simple, before they got in at 75%, let's say, and now it's 54%, that's a disparate impact for Asian American students. Now, the other position, which so far has prevailed, is that what you should do is look at the results after the new policy and determine whether or not the group is still getting in at a disproportionately high level compared to other racial or ethnic groups. And on this basis, the courts have said, even after the new policy was instituted, Asian Americans still get in at a much higher rate than their proportion of the student body or the applicant pool. And so they can't be the victims of a disparate impact when they're still outperforming every other racial or ethnic group. Now, Justice Alito, in his dissent from the denial of certiorari in the Coalition for TJ case, was very critical of that position and said that it would allow boards to essentially continue to diminish the opportunities or odds of admission for a group until they simply matched everybody else. So he thought that was completely inappropriate. Now, I want to turn to the other debate that is going on, and it relates to the meaning of discriminatory intent. And here, what has really been a challenge is figuring out what constitutes legitimate pedagogical concern about diversity and what constitutes illicit racial balancing. So I think that if you look at the recent brief seeking certiorari in the case from Boston, you'll see the Pacific Legal Foundation argues that illicit racial balancing is rife, that it's happening everywhere in these magnet schools. But the counter view is that instead what these schools are doing is just considering valid criteria for admission related to things like geography, making sure schools get a fair share of those seats based on socioeconomic status, making sure that children aren't penalized because they come from less affluent backgrounds. And all of those are legitimate factors. They do correlate with race because schools are segregated and because we see wealth and income stratification by race. But they say that doesn't mean that they're invalid or that our ultimate objective is a kind of raw racial balancing. And so far the courts seem to take the position that unless the role of race is so predominant that it's quota-like in the process, that race dominates every other legitimate consideration, that school boards are permitted to consider factors that correlate with race, and that does not amount to illicit racial balancing, even if at least one motivation is to promote diversity in the student body. So the truth is, we're still waiting to see how these issues will sort out in these cases. Now, I also wanted to move on from admissions and take a look at hiring. You'll remember that when I read you the letter from Professors Glader and Robinson, they were concerned that the new ABA standard on diversity was going to be fodder for attacking the mere presence of people of color in college classes and on law school faculties. Well, here we see a case that was filed recently and has gotten lots of attention. And it was filed against the Northwestern Law School just a few months ago by a group called Faculty, Alumni, and Students Opposed to Racial Preferences. The plaintiffs expressly cite SFFA to say that although that case dealt with admissions, affirmative action in faculty hiring is also impermissible. Now, if you read the opening paragraph of this complaint, you'll see that the plaintiffs characterize the use of these preferences in hiring as pernicious and pervasive. So I just wanted to share with you the very first paragraph of the complaint because it suggests that the American legal education is seriously corrupted. So it begins, faculty hiring at American universities is a cesspool of corruption and lawlessness. For decades, left-wing faculty and administrators have been thumbing their noses at federal anti-discrimination statutes and openly discriminating on account of race and sex when appointing professors. They do this by hiring women and racial minorities with mediocre and undistinguished records over white men who have better credentials, better scholarship, and better teaching ability. This practice, long known as affirmative action, is firmly entrenched at institutions of higher learning and aggressively pushed by leftist ideologues on faculty appointments committees and in university DEI offices, but it is prohibited by federal law. Now, that is a pretty strong opening, a fairly significant attack on hiring, not just at Northwestern, but throughout American legal education. And the complaint actually goes on to do something that has, to me, seems quite unprecedented, which is to name faculty and women who were allegedly improperly hired because they were, as the complaint puts it, patently unqualified. The complaint also names white male faculty who allegedly had superior qualifications and were passed over for an appointment. So this is a fairly dramatic lawsuit. It's got lots of attention. There's a lot of naming of names, including people on the appointments committee and in positions of leadership who allegedly abused their discretion. So this has sparked considerable concern. And the ABA's new standard on diversity and inclusion makes clear that law schools don't have to hire people with all the identity traits they've identified in their new standard. And as I mentioned, Professors Glader and Robinson have been strong critics of the ABA's position, arguing that it actually reinforces this notion that you shouldn't take race into account in hiring and that having a diverse faculty may be unlawful under federal statutes and the Equal Protection Clause. Now, the concerns are so great that the Association of American Law Schools, which is an association of all law schools and their faculty, actually, the executive committee of the association sent a letter to deans in August of 2024 because, as they put it in the letter, many member schools have expressed concern over recent lawsuits seeking to dismantle diversity initiatives. The most recent lawsuit was filed against Northwestern University's Pritzker School of Law, but NYU, Harvard, and other businesses and organizations have previously been targeted. The complaint against Northwestern, which alleges unlawful hiring practices, also attacks American legal education broadly, and it deploys harmful stereotypes about Black and other underrepresented faculty. The letter goes on to note that we also recognize that many states are proposing and enacting laws designed to restrict how universities conduct their hiring, and that these developments add further complexity to your hiring processes this year. So clearly the Association of American Law Schools, which has diversity as a core value, is concerned about these developments, although their proposed interventions are not necessarily as vigorous as one might hope. First of all, they offer to make leaders at the association available for consultation, and they urge law schools to nurture community and encourage faculty to join AALS sections. So although I think the letter is designed to assuage concerns, it's not clear that the solutions that are offered would necessarily be up to the task. Now, I wanted to just go beyond admissions to the curriculum and law reviews, because this Northwestern lawsuit also includes allegations that the law review impermissibly chose people on the basis of race for their editorial board, and also that they wrongly excluded authors based on race and gender from being able to submit articles to a special issue that was devoted to the work of Black women. And so the claim is that one cannot dedicate any kind of issue of a law review based on race or gender. So you couldn't have a special issue that featured only scholars of a particular race or gender. Interestingly, and I think I'm grateful for this, the complaint does not name names with respect to the students, but it clearly says that they engaged in permissible race-based preferences. Now, the other thing that's important to note is that some of the states have begun to impose restrictions. These are on public schools, and so they will address what faculty, including law school faculty at these public institutions, education can teach. Now, some states have actually banned instruction on divisive topics, while others focus on critical race theory and gender studies. And according to the Penn American Inventory, there are now bans of this type in 11 states. What I think is interesting is, law schools generally do teach divisive topics. I think it's hard to imagine how you would teach constitutional law without addressing divisive topics. And many law schools have courses on critical race theory or gender. And so one question is how these kinds of statutes will actually chill speech and whether they invade academic freedom at these public colleges and universities. Once again, the ABA Council on Legal Education has tried to respond to these developments by issuing a new standard on academic freedom and freedom of expression. The standard doesn't actually say that you have to adopt a particular position, but it does say that law schools have to publish a policy that protects the academic freedom, not only of faculty, but also the freedom of expression of staff and students. And so I believe this is really a response to some high-profile controversies at law schools like Stanford and Yale, where guest speakers were invited and there was a protest, and then there were various repercussions, and there's been a concern that we need to preserve civil discourse, but we also can't let people be treated punitively because they have unpopular ideas. Finally, I wanted to take a look beyond admissions by looking at diversity, equity, and inclusion initiatives. These efforts were really designed to go beyond admissions by creating structures that would support success for students from underrepresented groups when they arrived at colleges and universities. And some state legislatures have attacked, again, the infrastructure here. So they're not saying that you're treating someone differently with respect to admissions or even hiring. No, they're saying you have a structure to promote success of students, but it is too focused on a certain subset of students, and therefore we shouldn't allow it. And so we saw, for example, in Texas, here in Texas, that the legislature mandated that all state colleges and universities get rid of their diversity, equity, and inclusion programs. And so initially, the flagship campus at the University of Texas at Austin closed a multicultural center and then ended the scholarship that it had for undocumented students. But afterwards, a group called Accuracy in Media interviewed various people involved with DEI initiatives at colleges and universities around the state. And these individuals, when interviewed, didn't realize they were being recorded and said that they were finding other ways to promote diversity, equity, and inclusion. This was treated as an effort to circumvent the ban. And so UT Austin decided to lay off another 49 employees and disband its division of campus and community engagement, which had been designed to help sort of typically underrepresented students adjust to campus life. And I think they did this preemptively to avoid having the legislature come in, do an audit, and demand even more. But the legislatures are now going to be conducting 4-year compliance audits for all of the public colleges and universities. And so we'll have to see how those play out. But we do see here not only some efforts to discredit faculty of color and students of color, to change the admissions process, but also to dismantle the infrastructure that previously supported the success of these students. One way of addressing these issues has been to emphasize the ongoing non-discrimination principle and the need to ensure equal access to university programs, activities, and curriculum, regardless of race or ethnicity. And so to the extent that you are promoting equal access, that is not prohibited. On the contrary, it's necessary to prevent discrimination in the ability to use the resources that campuses offer. Now, I wanted to end by saying that I really welcomed the chance to be here today because I think this is a time when we really need to think creatively about responses to these developments. And I know that many of you out there have already been thinking about these issues and what you might do to make a difference. And so I do believe that we will see some shrinking of the numbers of Black and Latinx students in law schools. And they will therefore probably be in need of even greater mentoring and guidance. But the dismantling of the infrastructure of diversity, equity, and inclusion may mean that that guidance has to come through privatized channels rather than a kind of public infrastructure at public law schools. And I think that means that local bar associations, alumni associations, and other groups that care about the betterment of the legal profession will need to step in and fill that void. So I hope that you can support efforts to preserve diversity, to preserve other core values like academic freedom. And I'm very much looking forward to hearing ways that you have been trying to make a difference in through your own individual or institutional efforts. So with that, I thank you, and I look forward to your comments and questions.
Thank you very much, Rachel, for your very insightful comments. I now wanted to actually turn to Terrence Evans, who I know has been working already and spearheading efforts to preserve diversity, equity, and inclusion initiatives. And I wondered if you could perhaps share with us some of the work that you have done, Terrence, in that area, and then encourage our audience members to submit questions for Professor Moran. Terrence?
Thank you so much, Judge Bolanos and Professor Moran. It's an honor to be here with you. I'll briefly talk about some of the things that I've been doing in this space, and we already have a few questions that have been sent during the presentation. But one of the things I've been passionate about in the aftermath of the Supreme Court's decision in the affirmative action cases is helping institutions navigate this new landscape and maintain these programs. I was honored to be part of a group of lawyers who co-authored an amicus brief to the U.S. Supreme Court in defense of affirmative action. And one of the issues that we raised was the potential implications for Black and Brown students in colleges, universities, and law schools. And what we saw in California after Prop 209, where you had a very substantial reduction in admission and really it hurt the pipeline for legal talent and medical talent and talent across a number of professions. So I've been doing a number of trainings. I actually did one this morning for the tech industry. It's the third that I've done in the past 30 days, where I've met with leaders from some of the largest tech companies in the United States regarding how to navigate their DEI programs, their fellowship programs, their scholarship programs, their employee resource groups. Because as you mentioned, Professor Moran, there has been a chilling effect. And there have been so many companies, I believe Toyota recently announced just a few days ago that they were scaling back their DEI programs, their sponsorship of these programs, and modifying their employee resource groups that were focused on gender and race and LGBTQ status because of the interpretation that they've made that the affirmative action decisions require this. So I've over the past several months, I've met with the tech industry, leaders in the banking industry, the insurance industry, and various manufacturers across the country, trying to encourage these companies to not abandon their commitment to diversity, equity, and inclusion, and that there is a positive way forward. There are some questions, Professor Moran, for you that we got during your wonderful presentation. The first is, do the Harvard and UNC decisions still allow favored admissions for members of lower socioeconomic groups and first-time college grads from their families?
And the answer is yes. And I think one thing that you have seen is that colleges and universities are experimenting with what other categories to utilize to achieve the diversity they want in their student bodies and how much weight to give those characteristics. And so this is still permitted, but I think one reason that I wanted to emphasize the lawsuits over facially race-neutral admissions at magnet schools is that those cases are effectively challenging the use of race-neutral proxies if they lead to racial diversity. And so if the court were to endorse those challenges and say that everything that leads to better representation of Black and Latinx students is a suspect practice, even if it's facially race-neutral, that will be devastating for the ability of colleges and universities to use other kinds of traits and characteristics in order to address diversity concerns. The other thing I should mention is that race can still be used in essays, but there was a very mixed reaction among colleges and universities. Some feared that if they had any kind of prompt that mentioned race, they would be vulnerable to litigation, and so they just used open-ended questions. But the idea is that you're not just using the racial classification, you're asking the student how their experiences as a member of a racial or ethnic group affected them and how it might have changed their worldview or motivated them to act in certain ways or allowed them to overcome adversity. But that race is just one trait that might involve that. You might talk about disability for the same reasons. And so this is an idea that we don't want to use race as a category. We want to use it as an individual identifier. And so, I think your question is an important one, and we'll see. I also think related is financial aid, because if we begin to put more weight on socioeconomic diversity, but you don't make it financially feasible for people to enroll after they get the offer of admission, you will have challenges in achieving diversity that way. This was a lesson I think that was learned in Texas after the adoption of the 10% plan, because they got diverse results but then the students couldn't come because they lacked the financial wherewithal. So I think it's looking not just at the admissions policies, but bundling them with other things that universities and colleges can do: outreach, financial aid, as well as how they structure the admissions process.
As a follow-up to that, Professor Moran, we have another question here. In some states where race-conscious admissions measures have been prohibited for a while under state law, for example, California and Texas, universities have responded with race-neutral measures that admit from high schools based on class rank and in turn rely on residential segregation to create more diverse cohorts. Is this a flawed yet worthwhile approach? Are there better approaches that have emerged from these states' experiences? What else do these states' experiences tell us about the path forward?
Well, this is a very interesting question because we heard about the drops after Proposition 209 was enacted and prohibited affirmative action at California public colleges and universities. But over time, those numbers rebounded. But it isn't clear entirely why they rebounded. Some empirical research suggests that outreach was not particularly impactful. And that might be for the same reason when you try to mobilize voters, that just reaching out to someone isn't enough. You have to keep reaching out. You have to provide sort of the resources and knowledge and sophistication to participate. But outreach didn't seem to be the panacea that people thought it was going to be. The second thing is the percentage plans did have some impact. And that is related to segregation in the student body. And when you look at a lot of these magnet school programs, they're also using segregated schools in order to diversify the student body by guaranteeing a certain percentage to the middle schools. But it turns out that according to at least one recent empirical study, the biggest driver of diversification of the colleges and universities in California was demographic change in the underlying K through 12 student population. And so what you see is that demographic change. You can't be a public college or university in California without serving a very diverse K through 12 population. And this was especially true of the dramatic growth in the Latinx community, so that, you know, Latinx kids in K through 12 now in high school, they are the single largest group. They're incredibly dominant. And even getting in at far below their proportion of the high school population, they're still the largest entering racial or ethnic group in the freshman classes at the university. And indeed, the entire University of California is becoming an Hispanic serving institution. So without that underlying demographic change, it's not clear how diverse our colleges and universities and law schools would be in the state in the absence of affirmative action.
Professor Moran, there's a quick follow-up regarding the economics of uh, uh, diversity, equity, and inclusion. And you mentioned that there were some students under the 10% plan who would get admitted, but they didn't have the resources. And we know that just recently, the Fearless Fund, which was sued over its program to empower Black women entrepreneurs, they recently had to abandon that program. There are a number of diverse bar associations that give scholarships to the next generation of minority talent. I just had the honor of being at East Bay La Raza's annual scholarship gala this past Friday. And there's concern about how those minority organizations will continue these scholarship programs in the face of these cases that you were just talking about. And I was wondering if you had any thoughts, because I can see on the list of attendees, we have a number of leaders from minority bar associations. How can they maintain these programs without getting into hot water?
Well, first of all, you're quite right that race-based financial aid has been challenged. And also when the Biden administration issued its response to the SFFA decision, they did not include the use of race-based financial aid as an ongoing practice that colleges and universities could use to promote a diverse student body. However, you know, one question is, can you use financial aid with different indicators? So it could be someone who's going to work in the Black community. That means it's not based on your race, it's based on your career aspirations. Can you look at, you know, other characteristics? I thought it was really interesting that in response to the DEI ban in Texas, that the UT Austin campus ended its scholarship for undocumented students. Because you could argue that's not a race-based scholarship. There are undocumented people from a variety of races. It's based on your immigration status, but they nonetheless got rid of it. Now, as for the ways to do this, I think one way to do it, and again, this goes back to the privatization of strategies, is that we have told all universities that are public, as well as universities that receive federal assistance, federal monies, that under Title VI, they also can't use race-based practices. And so that's basically all colleges and universities. But that doesn't preclude a private actor who doesn't receive federal monies from engaging in race-based scholarships, for awarding race-based scholarships. So if your organization is not a public organization, if it's a private membership organization, if it does not accept federal funds, it's not subject to this mandate because it's not covered by equal protection. It's not a government actor, and it's not covered by Title VI because there are no federal funds received. So one of the problems is kind of the over-interpretation of the reach of the decision. And that has been happening not just because of risk aversion, which you hear a lot about, but because advocacy organizations are sending warning letters. And those warning letters make people think that they are subject to these restrictions, when in fact, as a private membership organization without federal funding, they are not. I mean, you'd have to look at your state laws, but they're not subject to the restrictions that applied in Students for Fair Admission.
And going back, Professor Moran, to the issue of the warning letters, we have a question here. It seems that an argument could be made that many of these efforts would have a chilling effect on speech. How much weight does that argument have in the courts today? Or has that been raised?
Well, you know, it is a very interesting question because the Bakke decision allowed diversity to be used, not because of equality concerns, but because of the institutional autonomy that colleges and universities enjoyed. They had the freedom to compose the student body, and in doing so, they could consider race to promote the pedagogical objective of having a diverse student body. So the Bakke decision, though it's typically thought of as an equal protection case, is really a First Amendment case at its core. And so what has happened is that the court has grown increasingly receptive to First Amendment claims by some constituencies. Churches, we've really seen a much greater level of regard for the institutional autonomy of churches and their members. Corporations, a very considerable regard for their freedom of speech, the use of dollars in campaign finance. And yet, what's so interesting is that colleges and universities' autonomy is increasingly under attack. We are not benefiting from the love affair with the First Amendment that exists in other parts of the jurisprudence. Now, part of that is an ongoing disagreement about what rights the faculty have, particularly at public colleges and universities, because what is being argued is that what we do is we're just employees and our speech is government speech. And so, for example, you know, the state of Florida can tell me what I can and can't say because I'm just an employee who's working for the state of Florida. Now, that runs counter to the idea that universities were unique and we needed to have First Amendment protections because otherwise universities aren't going to be very good incubators of ideas. And those ideas are important not just for private enterprise, like coming up with a new polymer. They're also important for democracy, that universities were the place where we figured out difficult issues and then we helped to promote democratic competency. But we can't promote democratic competency if we're muzzled. And so we are going to have to wait and see how challenges to some of these restrictive laws based on First Amendment rights come out. There are lawsuits pending in Florida, for example, which has probably been the most aggressive in limiting academic freedom. It's interesting there because with respect to the curriculum, that all started in K through 12 with efforts to ban African American studies, advanced placement program, but it's spilled over now into higher education. And also they have decided to do a very aggressive post-tenure review. And every 5 years, the faculty are subject to review. Now, the numbers varied, but at the flagship University of Florida, the first round of post-tenure review led to 20% of the faculty leaving, either because they anticipated a bad review or they got a bad review. And so someone there who is involved with the faculty representation said, we have to be honest, tenure is gone. We have 5-year contracts. So this is a separate dynamic, which is highly intercorrelated with the race and gender dynamics, but has a life of its own as well.
Professor Moran, we have a question asking for some clarification regarding scholarships, and I know you just spoke to this, and I'll be candid. I am the recipient of several scholarships through minority organizations. It's the only reason that I'm here practicing law today, and I'm grateful to those organizations. But in this question, the questioner comments on the frustration of not being able to use these programs to help needy students, and they're asking if there are any, is there any hope in maintaining it? Seems like you've already spoken that private organizations, so a private bar association, can continue their race-based to the extent that they have it scholarship programs, but I think there's still a fear of being sued. So even if they legally are allowed to, should they make any modifications? And would this also apply to companies that have had diversity scholarships in the past?
Well, and I think, part of the fear is we'll be ruined just by the lawsuits, right? We'll be financially bankrupted. I think that's one reason a lot of law schools are afraid they don't have like huge endowments to cover the costs. But I do think that if you want to think creatively, you have to think about what are the other criteria besides race or ethnicity or gender that correlate with your objectives in providing these scholarships. So, for example, let's say that you mentioned some identity affiliated bar associations, things, affinity bar groups. Let's say that you have looked back at who got your awards. Were many of them that, people who learned English as a second language, were they first generation? Did they come from modest households economically? Did they have a commitment to do work in underserved communities? What are the other traits that made them attractive holistically, right? Rather than just the race or gender. And then you can open it up more broadly on the criteria without using race or ethnicity or gender explicitly. And you wouldn't necessarily see a dramatic change in who gets these awards. You might also look, did they have a track record of already working in these communities, right? And so I think those would all be relevant criteria that you can use to revamp the way that you present the opportunity. And you're permitted to do outreach about the opportunity, at least under California law after 2009. So, you do the outreach. You also, I think, provide mentoring to individuals who are applying about how best to present themselves. And you do that to, make it available to all the applicants. But I think there are ways in order, to do that. Might be their immigrant status, whether they've had to be undocumented, whether they're dreamers, there's a whole slew of ways. I know that at one point at UCLA, we could not under state, I think it was state and federal law, give out awards, scholarship awards to the undocumented. We were barred from doing that at one point. And so the California Community Foundation went and created private monies, and they awarded the scholarships through the foundation rather than having it go through the school. I'm sure the dean was disappointed not to get the big gift for scholarships. However, it worked and it went on for years. And so there are ways to also partner with other organizations that do the awarding of the money, and try to, avoid running afoul of any state or federal restrictions.
And are similar efforts happening in Texas you mentioned UT Austin shutting down its program, but are there efforts to try to find other ways to help the undocumented students in Texas?
Well, it's very interesting because the treatment of the undocumented at UT Austin also correlated with a bill called SB 4, which the Texas legislature passed, which is designed to allow more room for state law enforcement to crack down on what is called the border crisis, right? And so there was a recent article about undocumented students actually being afraid to be arrested and deported under the new law if it goes through, which in turn has hampered their willingness to sort of apply, make known that they're undocumented, and to be like in centers that are designed to support them. And so this, I think right now, there's so many challenges on the immigration front that I'm not sure anybody is doing anything but playing defense at this point. But the combination of the attack on DEI and the attack on undocumented has made that a very freighted space. And the SB 4 litigation is ongoing. And so we don't know yet what parameters there will be for enforcement in the state and how much they will, speaking of chilling, chill the willingness of people to identify themselves as undocumented and benefit from resources for the undocumented.
Professor Moran, there's a follow-up question that we received, and this is about public opinion. Following the Dobbs decision, there seemed to be a groundswell of support for women's choice and the ability for women to make their own decisions. Have you seen anything similar with respect to affirmative action? Has it increased in public opinion, or has it not been much of a change in that regard?
Well, I find this also a very interesting question because in the wake of that Dobbs decision, you saw tremendous responses across the country with marches and protests. At the same time, Dobbs actually created room for people to do something, to act on those feelings that they had been wrongly denied a right that they should have, because it left to the states the option of creating, room for you to get to have reproductive choice if your state wanted to do that. And so you can mobilize at the state level under Dobbs and demand protection for this right that you want to see fully acknowledged. But the thing about the affirmative action decisions is, first of all, I was surprised at how quiet it was afterwards. And I didn't know if that is because the most significant beneficiaries are elites, and because a lot of schools basically have open enrollment. They're not competitive. And so for a lot of students, the decision is basically irrelevant to their lives. But also, it doesn't create a way that you could mobilize, because you can't go to your state legislature and overrule the US Constitution and Title VI. They're federal. So I think there was both less room to maneuver in a big way within your state, and also it may be that this is seen as a province of elites, and so there wasn't the same kind of groundswell, because abortion, I think, has been seen as relevant to women from all walks of life.
Professor Moran, what do you think that the broader impact will be on public trust in the legal system if the legal profession, particularly its leadership and the judiciary, become less representative of the growing diverse population in states, particularly like California?
Right. Well, first of all, I will say this: the legal profession has never been extremely diverse, although it is more diverse now than it has ever been. I think that one of the challenges we face is that there's already a loss of public confidence in law and legal institutions. And I think that is not because we're more diverse than we've ever been. It's because we're more polarized than we've ever been. And so we were just talking about the Dobbs decision. In the immediate wake of the Dobbs decision, levels of public confidence in the United States Supreme Court, which you would probably see as the paradigmatic, legal institution, were at an all-time low, the lowest they'd ever been since they started recording the confidence levels after Roe versus Wade. So we have a crisis of confidence. It also extends to other legal institutions like Congress, the executive branch, and one of the great challenges is to figure out how do we restore that confidence in the face of polarization and distrust. I think that the situation for law has been worsened by the, I think, integral role that law has played in all this conflict. We saw very high-profile lawyers involved with the challenges to the election. And it feels like law is seen now as an ideological tool rather than a way to promote civil discourse. And so I think that, again, the polarization and the challenges on diversity are linked, very significantly linked, but they are also different. You know, the polarization is around a lot of issues, of which race is one, and a very significant one. But it's nonetheless, I think, got another dynamic of its own that has been weakening law, because we are the civil institution that is supposed to contain these differences and allow them to be resolved in a deliberative and civil way, you know, and I don't know that we've been doing that as a profession.
Professor Moran, I'm wondering if you see a connection between some of the book bans, and I know that Texas apparently has the largest number of banned books of any state in the country. Most of these books were written by Black and Brown authors and women, and really sort of restrictions on um, accurate historical information. So, for example, if folks understood that for hundreds of years, people who were not white could not be admitted to many colleges and universities, even though their tax dollars were helping to fund those institutions, if there were restrictions on access to the legal profession. So, for example, in California, there was a statute when California was first admitted to the union that limited enrollment or admission rather of new lawyers to white men over the age of 21. If people understood this, they might understand some of the racial disparities and why these programs were created to address those issues. Do you see the sort of, I guess, the pushback on history, the pushback on access to books and knowledge as having any role in how folks are looking at the affirmative action decisions?
Well, there certainly have been efforts to change what kids learn at school. Those are not just about race. There's also a lot of gender-related efforts to restrict what students learn in school. Part of this has been driven by a parental rights movement. And people have argued that what actually happened was that during COVID, kids were learning on Zoom at home, and the parents could see what was going on because they were also at home, and they didn't like it. And so they got busy and mobilized. But these kinds of culture wars in the schools have gone on before COVID, although some people have argued that it really magnified the wars over what gets taught in the public schools. I think that, again, this is linked to a kind of privatization of our identities, you know, that we aren't part of a larger public good. It's all about what we want for our child, the way we socialize our child with our values, and we're largely indifferent to other people's values and the socialization of their children. This is playing out in the schools, but here in Texas, it's also playing out through an effort to create a universal voucher plan, which would be similar to the one in Arizona already adopted. And this would mean that you could essentially opt out and completely privatize your child's education by doing it at home or choosing a private school that reflects your values. And so it actually is linked to a kind of balkanization. What's interesting is the people who are fighting over what gets taught in the public schools actually think public schools still matter, and they want to control the agenda, but they don't necessarily have the vision of a common school, right? Where we come together around our differences and try to figure things out. But the push towards privatization, I think, is even more significant because it says we shouldn't have public schools where people from different walks of life come together. We should all hunker down in our own spaces, teach our own kids, and have our own agendas reflected. And that, of course, means that you don't get that robust exchange of ideas that we had hoped for, that you can't imagine other visions of the good life because nobody taught you there were other visions of the good life, or taught you about concerns that other groups have about their ability to achieve the good life.
There was one other question I had, Professor Moran, and this is when you were talking about the litigation involving academics at a number of these elite institutions, and the way that some of these plaintiffs were going about it, and basically all of the people of color who had been hired were essentially targeted, and the assumption was made that they could not have been qualified, or the approach as it relates to the demographics of some of these elite institutions that didn't see a decrease or a significant decrease in the number of Black and Brown students. The assumption was that they had to have been doing something wrong, or they had to have been taking race into account, because there's no way possible that, these Black and Brown students or faculty members could have gotten there on merit. And that I found that very disturbing. I was just wondering what your thoughts are about this presumption that if you are Black or Brown, you could not have achieved anything on merit, that it had to have been as a result of some other, mechanism.
Well, it's so interesting. First of all, I think that part of what's going on here is you see this issue over what's the right baseline, right? And so groups that say, when we project what the admission would be based on GPA and SAT, for example, their baseline is that. And anything that deviates from that is suspect. If you have a different view, you might say, well, gee, if ability is equivalently distributed across all racial and ethnic groups, the right baseline is actually proportionality. So anything that deviates from that is suspect. And so going on right now is this debate about what is the implicit baseline for measuring what is a fair distribution of the seats in these institutions. And the attacks, that are based on you didn't lose anybody. I mean, all these universities said race was a very small factor in admissions. It was a minor factor, but everybody thought, oh, they're lying, right? They're cheating. And so when the results don't change, they don't say, oh, well, maybe it was a small factor. They say instead, oh, you cheated. They're still cheating. So I think one of the things that those warning letters does is it kind of changes the burden of proof and says you're presumptively guilty of cheating, right? Rather than you could presumptively reach this class through just the exercise of your academic values and other factors that weigh in admissions. Now, with respect to the lawsuit, what is really concerning is that people get called out by name and basically pilloried, right, in this lawsuit as unqualified. They also mentioned people who didn't get jobs, which I think is kind of embarrassing for those people. They named the two finalists in the dean search and who got it and who didn't. And so there's just a disregard for the confidentiality of the hiring process, because most people assume, well, I'm going to go for the deanship, but if I don't get it, nobody's going to know. But now everybody knows, right, that you didn't get it. Also, you've had the spectacle of these white males who they, allege were wrongly passed over being contacted about whether they were wrongly passed over. So that's awkward too. But really, ultimately, what's terrible is the attack on legal education and the notion that, collegiality means nothing. We're going to give all these names out. We're going to essentially demean people in public, all because of an ideological agenda. That is the extent to which polarization has infected institutional norms of civility, comedy, and collegiality, because there is none of that in this lawsuit. And in the end, it's hard to imagine that people at Northwestern Law School feel that comfortable talking to each other in the hallways and whatnot, because you don't know what's going to end up in the lawsuit by name. I mean, it's really, really been very, very concerning. And other law schools are afraid to get sued. And unlike Northwestern, they might not have the resources to resist that kind of litigation effectively.
Well, Professor Moran, thank you very much for your very thoughtful and wise comments. And thank you so much for taking the time to help us conclude Hispanic Heritage Month. Thank you also, Terrence, for all the work that you're doing to preserve diversity, equity, and inclusion programs and for helping us put together this program. Thank you to everyone who joined us today. I hope that this was an opportunity for you to learn a few things and continue to increase efforts to preserve diversity, equity, and inclusion in our profession. On behalf of the Elimination of Bias Committee, I want to thank everyone and wish everyone a great week. Thank you.
Thank you. And may we take a quick picture before we go?
Oh,
So
yes,
that,
absolutely. Let's do that.
okay. On the count of three, 1, 2, 3. Make sure that came out. Okay. Thank you so much.
Great. Have a great day, everyone. Thank you for joining us.
Take care.